Yeah, hello?
Yeah. Okay. So every AV team is working on the talk. So when you're ready to talk, we can speak.
Perfect. Hello? Can we please sit down? We're being asked to start, so. Okay. Good morning, everyone. I didn't know winter was coming here to Miami, but it's a pleasure to be here, and thank you for inviting us. The topic today is very interesting, particularly following up from the prior panel. And it's true that in time of crisis, we are exposed to a core conflict. On the one hand, investors need treaty protection because it's particularly in times of crisis when they are more vulnerable. And on the other hand, we have the states, which require some kind of flexibility to respond to the crisis. So neither total state discretion nor strict business as usual would work. And today we're here to discuss exactly that. How should tribunals balance these opposing interests to ensure that there is meaningful treaty protection for investors during difficult times, flexibility for the states to address the concerns of the population, and whether the burden of the crisis should fall on the investor, on the state, or should be shared? And if it's going to be shared, how do we share that burden? We have seen a lot of different crises that have gone to investment arbitration. We have seen economic crisis. Argentina has been a big crisis that went to exit many, many times, as we saw today in the prior panel. We had political unrest, social unrest, and of course, health issues like the pandemic that we cannot forget. And tribunals have looked at these issues in different stages of the arbitration proceedings, at the liability state, at the defense state, and sometimes even in damages. So we are going to hear all about this today from our panelists, and we're going to pose a question to them. Tribunals should consider the political context of the government's conduct, such as political instability, social unrest, or economic crisis, as mitigating factors when determining a state's responsibility for breaches of international law. Yes or no? And we have 4 excellent panelists today who are going to discuss and debate this issue. So for the proposition that tribunals should consider the political context, we have Catalina Echeverri and Felipe Merizalde. So Catalina is a partner at Wardstone based in Paris. She advises clients across a broad range of sectors. And Catalina has a background in public policy from the University of Oxford, which will be very valuable in the debate of today. Juan Felipe is a partner at Adel and Merizalde, based in Bogota. Juan Felipe has more than 18 years of experience in commercial and investment arbitration, particularly involving Latin American parties. So on the other side, we'll have the proposition against the proposition that tribunals should consider the political context. We have Christian Lithley and Carmen Martinez Lopez. Christian is the US head of international arbitration and co-head of the Latin American practice at Herbert Smith in New York. He has over 25 years of experience focusing on international, commercial, and investment arbitration, and dedicates much of his time to practice in relation to Central and South America. And Carmen is a partner at Three Crowns. In Madrid, she specializes in commercial and investment arbitration with a particular focus on Latin America and Spain. So I must know that all of the panelists have been praised by clients and peers for their persuasive oral argument skills. So we're going to have fun this morning. And with this, to launch the debate, quick question to get you started. Should tribunals ever consider the political context of state conduct when assessing liability under international law? And should the type of crisis, if we're talking about economic or health, affect the latitude given to states in their conduct under investment law? You have 20 minutes each, and then we're going to have rebuttal.
Thank you, Noyana. And before we start the chess clock, if I may just thank, on behalf, I guess, of the four of us, the MIAS organizers for inviting us. And as a Latin American, I have to say that what you guys are doing is impressive. 10 or 15 years ago, when we came to Miami, it was only for the ICC and Mangos. But now you have turned Miami into this really important place of arbitration. I have to say it's one of the most impressive seats of arbitration in Latin America, and that's mostly because of what you guys have done. So thank you. Now we can start. And thanks, Noyana, for this nice introduction. And in the next 20 minutes, my colleague Catalina Echeverri and I will explain how not only tribunals should consider the political context of the government's conduct, but that they actually already do it. In the first 10 minutes, I will show you how the current legal standards of ISDS system already grants the states ample deference when facing difficult situations. So there is nothing aspirational to do, as the premise says. It's already done that way. After that, my colleague Catalina will explain that even if you were to consider that the standards are somehow insufficient or that the tribunals sometimes misapply these standards, there are public international law exceptions that allow the state to take these measures when justifiable reasons arise. And in any case, in damages calculation, the tribunal should also take into consideration these political context. And as I anticipated, the current legal framework of ISDS is sufficient, and I have 6 premises that will confirm this assertion. The first one is that the Fair and Equitable Treatment Standard, or as it's known, FET, has been widely interpreted for allowing states to modify its legislation or regulations, even if those modifications affect the rights of a foreign investor. And this was clearly established by many tribunals, including the Pavlovsky versus Czech Republic Tribunal, when it stated, and I quote, "There is a principle that legislation and regulation are dynamic, and that absent a treaty obligation to the contrary, states enjoy a sovereign right to amend their laws and regulations and to adopt new ones in furtherance of the public interest." Accordingly, and I move to my second premise, the FET standard should not and cannot be construed as an insurance against changes in the regulatory framework. As the Saluca Tribunal stated, and I quote, "The host state is not required to freeze its legal framework, and no investor may reasonably expect that the circumstances prevailing at the time of the investment is made remain totally unchanged." As a consequence of these 2 premises, ladies and gentlemen, states have a discretional right to amend its legislation when public policy concerns justify such an amendment. The third premise is that when tribunals analyze the legitimate expectations of investors, and as this learned audience knows, legitimate expectations is an important factor of this FET standard, several tribunals have indicated that investors cannot rely on legitimate expectations that they had at the moment of making the investment, that the current legal framework was not going to change. This principle was clearly espoused by the EDF versus Romania case, and the silver-rich Italy, among many others, when they state, and I quote, "The legitimate expectations of foreign investors cannot be that the state will never modify the legal framework, especially in times of crisis," as the title indicates. But certainly investors must be protected from unreasonable modifications of that legal framework. And that last part brings me to my fourth premise. I concede to my colleagues when they will tell you that state regulations can breach the FET standard. There is a limit to the state's capacity to regulate, but that limit is unreasonable modifications to our regulatory framework. If the state, for some reason, invokes a bogus justification to affect the investors' rights, then the state should be liable, and I agree with that. But there is a very high threshold that the investor has to meet. As explained by the Infracapital versus Spain Tribunal, to meet this high standard, the conduct of the host state must not only frustrate those legitimate expectations, but also be unreasonable under the public international law definition of unreasonableness. And this tribunal, the Infracapital, just like the IS versus Spain, both analyzing the same measure, concluded that the requirement for reasonableness requires a balancing or weighting exercise so as to ensure that the effects of the intended measure remain proportionate in regard to the affected rights and interests. Provided that there is an appropriate correlation between the policy sought by the state and the measure, the decision by a state may be reasonable under the FET, even if others can disagree with that decision. It concludes that a state can thus be mistaken without being unreasonable. The fifth premise is that when assessing if the measure is unreasonable, tribunals not only have to look at the state's state of mind, but also at the investor's own conduct, including what many tribunals have called an exercise of due diligence into the political, socioeconomic, cultural, and historical conditions of the host state. If that state has a tradition, for instance, of radically changing the regulatory framework, or there was an expectation that the regulation was somehow going to change, then the investor did not conduct proper due diligence, or the investor willingly accepted the risk of the modification happening. And for instance, in the Gaspar versus Costa Rica case, the tribunal considered due diligence as a key factor for assessing the state's conduct. The tribunal held, and I'm going to aprovechar que estoy en Miami and I can cite in Spanish, the tribunal held that aunque las legítimas expectativas del inversionista en cuanto a la estabilidad del marco regulatorio pudieran ser relevantes en el caso, el tribunal observa que la demandante no alega haber realizado una debida diligencia sobre el marco regulatorio vigente al momento de realizar su inversión, ni haber recibido en aquel momento compromisos o declaraciones por parte del Estado en cuanto a sus posibles evoluciones. Por lo tanto, el demandante no puede haber tenido ninguna legítima expectativa en cuanto a la evolución del marco regulatorio. Due diligence is therefore fundamental if the investor wants to argue that a change was contrary to its legitimate expectations. And the sixth and last premise, just like FET, the expropriation standard also grants ample deference to the state when analyzing whether an alleged expropriatory measure was adopted for public purpose or not. This analysis, as you all know, is fundamental to determine if an expropriation is lawful or unlawful under international law. If the expropriation was a measure taken for public purpose in a non-discriminatory way, respecting the due process, and with the payment or efforts to pay a just, prompt, and effective compensation, then the expropriation is lawful. And many tribunals have considered that really strong expropriatory measures were lawful because the state argued, simply invoked a reason of public purpose. Just take a look at, for instance, many of the Bolivian nationalization cases, Ecuadorian cases, or some of the Venezuelan cases. And how does the tribunal look at this public purpose? Does it do a de novo exam as to whether the public purpose was reasonable or was necessary for the state? The answer is no. When you look at decisions of tribunals, and I have, for instance, this citation from, now I lost the footnote, I apologize. But it states that the tribunals must thus first assess whether there existed a public purpose. And it concurred, this tribunal, with respondent that for purposes of these assessments, states deserve broad deference. In the words of the LIAM tribunal, this is the important quote, the state is free to judge for itself what it considers useful or necessary for the public good. International tribunals should thus accept the policies determined by the state for the common good, except in situations of blatant misuse of the power to set public reasons. Probably my colleagues at the other side of the table will tell you that this difference between lawful and unlawful expropriation is artificial or simply anecdotal, but it's not. It's very important for the purposes of damages calculation, and also because it legitimates the state's decision to take an expropriation. So, Noyana, thank you for these 10 minutes, and the answer is there is nothing to change because the legal framework already somehow obligates the tribunals to take into consideration the state's conduct.
Thank you,
Catalina
Felipe.
will take
And on that note, as Juan Felipe anticipated, I will argue that tribunals sometimes, not always, fail to give the broader political context in which governmental conduct occurs proper legal effects, particularly when assessing the duty to provide compensation arising from both lawful and unlawful government action. And I will focus on two issues where tribunals may send deeply troubling messages that run counter sustainable economic development, which is one of the very goals that the investment protection system was designed to advance and from which it ultimately derives its legitimacy. First, I will argue that restrictive interpretations of exception clauses tell states, of course, you may take measures to protect vital public welfare objectives, but only if you can afford to compensate foreign investors affected by those measures. And I put to you that this is unfair, especially for developing countries. Second, some tribunals' approach to damages may signal to investors, if government action harms you, you may be compensated so generously that you end up being better off than if the measure had never occurred. Let me begin with the restrictive interpretation of exception clauses. Some investment protection treaties include a general exception clause providing that nothing in the treaty may be construed to prevent a party from adopting or enforcing measures, for example, to protect human, animal, or plant life, or to conserve exhaustible natural resources. Other exceptions refer to the maintenance or restoration of international peace or security, or the protection of its own essential security interests. What is or should be the effect of these exception clauses? I contend that where the exception applies, the state liability is excluded and no compensation obligation arises. Tribunals that accept the applicability of the exception in light of the political context, but nonetheless impose a duty to compensate, do not accord that context is full legal consequences in excluding states' liability. In the cases arising from the Argentina economic crisis, tribunals adopted divergent approaches, and the issue generated substantial debate. More recently, in Ecuador, a case under the Canada-Colombia FTA concerning Colombia's measure to protect the Páramos ecosystem and affecting investors in the mining sector, the majority held that the clause merely permitted Colombia to take the measures, but did not shield it from paying compensation to the investor of the damage that the measures could cause. The tribunal said that environmental and investment protection must coexist in a mutually beneficial manner and found no justification for allowing Colombia to protect the environment without compensating the investor. The tribunal's interpretation not only contradicted the position of both Colombia as a respondent state and Canada as a non-disputing party, but also ignores that this provision already reflects the state's balancing of competing interests. In limited, clearly defined situations, investment protection must yield to higher public purpose objectives. Telling a state that it may adopt necessary measures but must still compensate investors is equivalent to telling it that it cannot take such measures without breaching its international obligations. Because the obligation of compensation, except in the case of expropriation, only arises from an international wrongful act. Thus, while the tribunal claimed that investment protection and other public interest objectives stand on equal footing, in practice, even when considering the context, it treated investment protection as paramount. In other words, it redid the balancing that the states had already done when including a provision that limited the protection to foreign investment. Not all tribunals take this approach. In SEDA versus Colombia, another recent case concerning measures taken by the state against organized crime, an essential security exception was interpreted according to its purpose. The tribunal held that investor rights are, and I quote, a creature of state sovereignty and limited by it, and that the exception placed Colombia's measure entirely outside of the treaty. In other words, if the exception applies, there is no violation, and that means no compensation. We may ask ourselves if the outcome would have been the same in the SEDA case if the environmental interests were at stake and not the fight against organized crime, as in Ecuador was an environmental interest at stake. And we could argue that the result should be the same, since the tribunal in SEDA found that the notion of essential security could extend beyond territorial integrity or military security to include environmental safety and economic stability. And I turn now to my second point, which is the determination of compensation for treaty breaches. Now we're talking about unlawful conduct. With a contention that I am partly borrowing from an excellent article by Antonio Marsal that I will be happy to share with you after the conference. Today, tribunals treat quantum as a technical fact-finding exercise. Full reparation is equated with restoring the fair market value of the investment, which in turn is often determined through a DCF. The proposition here is not that valuation techniques should be dispensed with altogether, but that they should not be treated as objective realities, absent from normative judgment. For this reason, the determination of compensable harm should also include certain equity and contextual considerations that could mitigate the state duties to compensate, and which currently are not widely applied. The truth is that the determination of the fair market value of an investment assumes a fictional market, open, unrestricted, and liquid, even when no such market exists. In Occidental versus Ecuador, for example, the tribunal valued a concession as if it were freely sellable, despite clear restrictions that would reduce its price in normal conditions. This inflate value, treating assets as more marketable and profitable than they are. Tribunals also tend to treat country risk in a way that further widens the gap between fair market value and real-world market valuation. The prevailing approach, although with some exceptions, is to include only general country risk in the DCF, while excluding the specific risk that the state may adopt unilateral measures. We see the case of ConocoPhillips, for example, even though such a risk will unquestionably be priced by any real-life investor. This exclusion is usually justified as a necessary way to avoid rewarding unlawful state conduct. But whatever its policy rationale, the effect is clear. It favors investors by constructing a fair market value standard that assumes a safer, more predictable environment than it actually exists. Fair market value, therefore, cannot be portrayed as a neutral or empirical market observation. It is a legally constructed benchmark shaped by normative choices. So because this methodology is neither objective nor neutral, there is no reason for tribunals to disregard other equitable or contextual considerations when defining compensable harm. Factors such as the state's financial capacity to pay the award, the investor's legitimate expectations, the public rationale of the measure, and the nature of the breach should also inform the compensation analysis, not as an exception to the full reparation principle, but as part of determining the very boundaries of compensable loss. And the dangers of ignoring context are stark in Sethi and Copper versus Pakistan. In an award rendered in 2019, a tribunal applied the DCF to a project that had never reached production, despite overwhelming evidence of systemic corruption, political instability, and serious security risks in the project area. The tribunal ignored the party's own acknowledgement that the project likely could not proceed and assumed decades of highly profitable operations. And what is the result? An award of nearly $6 billion based largely on hypothetical profits, which consisted or were equivalent to 16% of Pakistan's budget for that same year. Valuation must reflect real-world constraints, including limits on marketability and regulatory powers. Investors should not do better in litigation than in real life, because this is what is causing the crisis of legitimacy of the system. We cannot forget that even when a state breaches international law, punitive damages are not an available remedy. Yet, excessive speculative awards grounded in fictional markets and optimistic projections operate punitively in practice. They punish not wrongdoers, but taxpayers who ultimately bear the costs of the inflated compensations. And I think our time is up.
You have a couple of seconds if you.
It's fine, thank you.
Okay, thank you very much. I think there's a lot to unpack there, and at the moment I'm more for the proposition that basically the investor has to bear the full burden of the crisis. What do you have to say? Challenged.
Exactly. We might be making a challenge to our chair. Thank you, Noyana. So, in order to address this, I'm going to start at a higher level. And I want to tackle 3 core questions. The first is, does international law already accommodate the political context? And so everything you read there, I'm going to use the shorthand of political context. And I'll address what Felipe was introducing. The second is that political context, if it does exist, is it objective or subjective? You've heard the argument that it could be objective, but it should also be subjective. And we oppose that suggestion. The third question will be, what purpose does international law and ISDS serve? So I'll come back to all of those points. But beforehand, let me ask you to raise your hand if you have a teenager as a child. A pre-teenager who has illusions of being a teenager, perhaps. Okay, good. Yes, exactly. Everyone's hands go up. And for those who didn't raise a hand, you were a teenager once upon a time, I suspect, fairly recently. So therefore, let me group you all in the same category. So you know that a teenager can occasionally have a meltdown moment and do something wrong. And when that teenager is confronted by their parents or a teacher, they may start giving you excuses. Oh, I was having a bad day. My friends have been nasty to me, and I was suffering anxiety. There's so much pressure on me these days, you've no idea. And you just don't appreciate what it's like to be a teenager these days. You just don't get what's going on. Does this sound familiar to some of you? Now, do those excuses carry any weight or any sway with the parent or the teacher? Almost certainly not. Why? Because they aren't new. Indeed, there aren't any new circumstances a teen could raise before a parent or a teacher. Now, history may change the means and the medium through which teenagers have to deal with life's challenges, but the core challenges remain the same and have since time eternal. And so it is with states and how states handle circumstances that prompt the question of whether a state is responsible under international law. And the simple way of seeing today's proposition and how our colleagues over the other side of the stage have put it to you is, should we accommodate that predictable unpredictability? Should we factor into our judgment the actual or perceived aggravating circumstances, whether it be political, economic, or social, that create or cause a situation? And let's not kid ourselves. Here, the proponents of this motion are saying that consideration means giving the state the benefit of the doubt to avoid state responsibility. So essentially today, you are being asked to vote, if there is a vote, whether states should be cut some slack here because of what is going on inside their country or perhaps outside the country. And we oppose this proposition. Considering the political context is like putting the fox in charge of the henhouse or the teenage in charge of its sole behavior. There has to be a higher standard, one that is not necessarily blind to political context, but one that is not influenced by it. There has to be an objective control of how responsibility is judged. Otherwise, political opinion and subjective opinion will be the key determining factors when assessing state responsibility. And that would be a consummate disaster and a derogation of the most basic principles of international law. Now, Carmen will consider certain other aspects, but let me take the first of the three questions that I introduced. So, international investment law provides a means of mitigating political risk, the very architecture of what investment law is. But does investment law also factor in, to some extent, political context? Felipe headlined this. And I would agree, to some extent, the answer to that question is yes. And let me explain. There's a few ways it does. But importantly, we see this proposal, this motion, as being a request for even more consideration, even more slack to be cut in favor of the state. So first and most obviously, by virtue of a treaty, and treaty protection is gained by a state making a political decision to enter into that treaty. The state is the sole decision maker in entering that treaty and agreeing to some investment dispute. And so that consent hinges on a political decision. And this is one way in which political context kicks in. Does the state want to bind itself to international standards? And once it does, it must carry the consequence of that. Political instability or social unrest or economic crises, these are the types of political context that are all, and I really hate to quote Donald Rumsfeld, known unknowns. If we get to a point where predictably unpredictable types of aggravating factors mitigate a state's responsibility, then we're allowing the state to absolve itself. And that is the core of our opposition. The state is saying that notwithstanding the political or economic or social terrain that a state must confront, it is going to be able to largely ignore that when it comes to assessing the state's responsibility. And this has the effect of allowing a state to shift the blame for its potentially bad behavior onto those events, whether they be a cause or a consequence. Now, how else does international law already accommodate political context? Well, from both a procedural and substantive perspective, there is consideration, Felipe is correct, of political context. As a matter of fact, economic unrest, social instability, political turmoil, all may appear as facts that trigger events for alleged state misconduct, that in turn leads to allegations of state responsibility. And therefore, wouldn't it be odd if the very event that triggered responsibility is used as the very defense to allow that misconduct to have occurred? Now, also as a matter of procedure and substance, a tribunal may be presented with facts and as mitigating factors. For example, Argentina's depacification, an economic crisis, a deep economic crisis. A tariff deficit in Spain. Political moves made by left-wing governments, for example, in Venezuela, when the state felt that property and IP rights could be taken back. Or banking crises in Cyprus, or the debt crisis in Greece. And as I list these out, I hope you're reacting the same way I am, which is, weren't some of these political or economic or social crises self-made? Indeed, some could be said to have been self-made. And this requires me to remind you of an important principle of international law, the continuity of state responsibility. Governments can be blamed for political or economic or social events, but today's proposition does not talk about political responsibility. We're talking about state responsibility, and the continuity of state responsibility means the state carries the responsibility for the behavior of former governments, as well as external influences. And now, one more observation on how international law already considers political context. There are extreme circumstances that a state cannot be said to have reasonably anticipated. And notwithstanding the high standards of international law, there is some margin of appreciation afforded to a state, not least depending on the wording of an applicable investment treaty. For example, treaties may now incorporate today the right to regulate national security, public health, or excluded conduct. And these are all areas where a margin of appreciation for states is being afforded to them, perhaps relating to economic, social, or political influences. However, and this is important to how you vote, we, Carmen and I, assume that today's proposition seeks to extend the mitigating factors beyond the application of already existing defenses like this defense of necessity, or aspects of lex specialis that I've mentioned, like the right to regulate in public health. And instead, today's proposition seeks to introduce new defenses and new off-ramps for states to avoid state responsibility. And that, we say, is simply too far. And that takes me to my second question. Is the political context subjective or objective? Now, this goes to my earlier point that if such factors are to impact a finding of state responsibility, then we are facing a race to the bottom. Instead of maintaining a floor of international conduct below which a state's conduct should not drop, we would instead be allowing the floor to rise and fall depending on the subjective assessments of events. For example, should a foreign investor expect to have its investment subject to conditions in a state that can drastically and summarily change overnight because a sitting government was elected on a discriminatory or unreasonable or arbitrary platform of country first and foreigners second? Of course not. To do so would endorse and potentially fuel political reactionism. To do so would undermine the very fabric of international law, which is to establish basic minimum standards of treatment. Those are non-discriminatory or are founded in reasonable, proportionate, and well-reasoned principles of international law. Remember, in the case of NIR and Mexico back in 1926, the US-Mexico Claims Commission articulated that state conduct violates international law only if it amounts to to an outrage, bad faith, willful neglect of duty, the basis for shocking the conscience. That tribunal and a number of others that held unreasonable conduct must be that which shocks the conscience, were a way of stating that the answer to this second question is that political context should be objective and should only be a consideration in the most negligible way. Proportionality, reasonableness, non-arbitrary conduct, fair and equitable treatment, non-discrimination, legitimate expectations, all imbue standards that have been repeatedly found by international tribunals to be objective. Now, why is this important? Well, what better example than the world we live in today? International law, the Bretton Woods Accords, multilateral system of international law, all require a grown-up in the room. And that is the basic minimum standard. Let me pause there in the interest of time.
Well, thanks very much. I have the benefit of going last, and so I want to go back to some of the points that were made, and I want to try to refocus the question here, because I think the great advocates that we have on the other side have actually made they've done a great job at obscuring the relevant question and at obscuring as well the key points that must and should inspire the answer to this question. And so allow me to go back to the exact proposition that is before us, right? And it's not whether or not, in certain circumstances, the conduct of a state is going to be excused by truly exceptional political circumstances, right? We all agree that that's the case. There's the state of necessity there in many of the BITs, there's the state of necessity under international law. There's no question about that. There's no question about the fact that some tribunals, particularly in light of some of the language that Catalina was referring about, such as the SEDA versus Colombia agreement, have in fact given weight to that language and excluded international liability from states in truly exceptional circumstances when the treaty so provides or when the conditions of Article 25 of state responsibility are met, right? But that's not the question before us, right? The necessity defense does operate in an absolute manner in truly extraordinary circumstances. The question before us is way more nuanced than that. It is whether the tribunal should apply as mitigating factors the existence of a certain political context, such as political instability, economic crisis, social unrest, which do not arise to that level, right? We're not talking about the state of necessity here. And so the fact that political context, when truly relevant and when it truly rises to a certain level, is already considered by international law, precisely is the reason why you should vote no to this proposition, right? Now, the answer to the question before us must be a resounding now, and I just want to quickly go back to 4 important key points that I feel we're somehow forgetting in the debate. The first point is what investment arbitration is really about. And it's about the rule of law. And it's about the rule of law being applied, right? And there should be no flexibility when we're talking about the rule of law, particularly in times of crisis, in times of economic crisis, in times of a political crisis, right? Because that's precisely when a rule of law is going to be under attack. And that is when it is particularly important to require, in absolute terms, compliance with the rule of law. Or is the proposition that is being put by the other side that, you know, if there is a social unrest or economic crisis, it is okay for a state to succumb to, say, xenophobic or arbitrary measures? Of course not. This is precisely the risk that we're trying to protect here. And so let me break down this by standards, because we heard a lot from the other side about legitimate expectations and FET, and I'm going to go back to that. But before I do that, let's talk about some of the other fundamental protections of these treaties, right? Denial of justice. I mean, surely our friends opposite must accept that a state is not allowed to deny due process to an investor, no matter the political context, right? No matter the political context. These are fundamental protections of the rule of law. Same goes for expropriation, right? Is the suggestion that a state can actually expropriate without compensation when it's just in need of cash because of an economic crisis? I mean, again, that does not work. And take FET that Juan Felipe was referring to, right? Why would the internal difficulties of a state, an economic crisis, a social unrest, some political difficulties, why would they justify an arbitrary or a discriminatory measure by a state? Now, we heard Juan Felipe mentioning legitimate expectations. We accept that the context in which an investor decides to invest in a whole state might be factually relevant to the reasonableness of the investor's expectation. We accept that. But the question before us is different, right? The question before us is what happens when the state takes measures, generally many years after the investment was made by the investor, right? What happens when the state takes those measures and it says that they can be mitigated by the political and economic and social context, right? They do not justify the state to, for instance, renege from a previous undertaking that it gave to the investor, just because now perhaps the state needs the cash, right? And I think the Spanish cases illustrate this very well. You promise the investor not to change their remuneration, crisis or no crisis. I mean, of course, during the lifetime of these investments, economic crisis will happen. We all know that. Economic crises happen from time to time. But the point is, you made a specific commitment to those investors, and you need to comply with that commitment. So again, this goes to the heart of the rule of law and the heart of what the system really is trying to do and to protect. Now, to my second point. My second point is to remind ourselves of the need to respond to this question in a principled manner, in a manner that actually offers a predictable outcome to the investors and to the state. And I say this is particularly so in today's world, when we are facing a legitimacy crisis, and accepting that certain political, economic, or social circumstances might operate as mitigating circumstances is anything but principled and certainly does not lead to certainty. So let me offer some examples. I mean, are certain crises more deeming of protection than others? That was a question that Noyana offered to start the debate. I mean, why? Which ones so and why? You know, what? Shouldn't the tribunal also consider the role that the state played, if not in creating that crisis, but certainly in responding to that crisis? You know, what are going to be the consequences once a tribunal accepts that indeed those operate as mitigation factors? What are we saying? That you breach the treaty by just a little? I mean, what does that even mean? It's so unprincipled. And let me briefly touch on the damages point that Catalina was making, right? It has been tried in a number of cases, notably by Italy, for instance, to argue that in circumstances in which the state was acting for a public purpose or for a legitimate purpose, the amount of damages should be reduced. And the tribunals have rightly rejected so, right? And they've said, what I'm applying are principles, Chorzów principle of full reparation, right? And indeed, Catalina was making, of course, a very nice point rhetorically, which is, well, what about the state financial capacity? Should that inform compensation? But when you think about it, it's so unprincipled, right? Why being poorest allows you to compensate less? I mean, and let's think about this in a moment from a systemic point of view. This is precisely going to create the opposite of what we're trying to create. It's not going to attract more foreign investment to that country. I mean, investors are just going to think, well, even if I invest in certain countries, I'm not going to be fully compensated because somehow the tribunals are accepting this totally unprincipled point that because the country is poor, I do not deserve my full compensation. So I'm offering you principles. I'm offering you Chorzów. I'm offering you full reparation. I'm offering you a principled solution. What you're hearing from the other side is a plea for equity, not principled, and is a plea of equity which might massively backfire in terms of attracting investment, which at the end of the day is what we're trying to do. Yeah?
10 seconds?
Okay, so just very, very quickly, but I just have a third and a fourth point. And my third point is, if the negotiators of the tribunal did not allow for these mitigating circumstances, then it's not the role of a tribunal to do that. And then my very last point is, let's be careful and mindful of the perverse incentives that we might be creating where we're introducing the rule that our friends propose to introduce that. We can develop that a little bit further in rebuttal.
Thank you. Very compelling. So you have 11 minutes to rebut because we got 1 more minute here.
Thank you very much. I think it's not very useful for the debate to have discussions in abstract, and I think that's what the other party is doing. So what they're telling us is, do we agree that states should not deny justice? Of course, we agree that states should not deny justice. Do we agree that states should generally pay compensation for expropriation? Yes, we agree that in certain circumstances, and I'm going to go into that. That's why this proposition focused on specific cases where the relevant framework was misapplied. Because the main point here is that investment protection, again, is a creature of consent of states. States have no obligation. States decide how much protection they want to give through the treaties that allows investors to sue them. So, for example, in the case of expropriation, we have treaties like the FTA between Colombia and Canada that tells you it's not indirect expropriation when a measure constitutes the legitimate exercise of police powers, for example. That is the will of the states that entered into that treaty. So in those cases, it could be justified that a measure that could otherwise be characterized as indirect expropriation will not reach that qualification. So we need to have discussions in concrete cases. We do agree that there is a framework, and we are not saying that the framework should be extended. We're saying that the framework should be applied. And I thought it was interesting that the other party brought this analogy of the teenager asking to be cut some slack, but that's precisely what investors do. Because we cannot forget that investments have some returns, and that those returns are usually tied to the level of risks that investors assume. And in that level of risks, they also have to account for political change. They also have to account for regulatory action. And this brings me to the point of what is the purpose of the system? The purpose of the system is not to protect investment because if it is a good in itself. We must protect investment even if it leads the state to ruin, even if it leads to the fact that the state will no longer accommodate any investment because there's nothing left. We protect investment only as long as it also will encourage economic development. So this is something that we need to take into account. The investment protection system is not there to shield investors from regulatory action when that regulatory action is legitimate. We are not arguing that states should be completely exempted unless if the treaty provides an exception clause, for example, from any scrutiny of their measures. So I think that's, just to sum up that, I don't know how much time I took.
No, you can.
Because Juan Felipe is also going to.
You have 2 more minutes.
Okay, so Juan Felipe. Because
you have 2 more minutes.
Okay. So just to recapitulate, I think we need to ask ourselves fundamental questions about what the purpose of the system is. If we are saying that the purpose of the system is protect investors, private investors, for the sake of it, then this doesn't make any sense for states. We are protecting investment as long as it does not affect and puts the economic development of the state in peril. Second, we cannot have discussions in the abstract. This party is not saying that we should be cut some slack. This party is saying we should apply the provisions that are there precisely to safeguard the state's capacity of government action in times of crisis, and it's not being applied properly.
Excellent points, Kata, and I'll see if in these 5 minutes I can do 2 points. The first one is that I really like Christian's call for hands. I think it was nice metaphor. So I'm going to try to do it as well, and I apologize if it doesn't go that well. But how many of you guys suffered any consequence from COVID, the pandemic? You couldn't go to the university, you couldn't go to the nightclub. I think that everyone raised their hands. Okay, how many of you guys have seen 2 or 3 investment arbitration cases arising out of measures taken because of COVID? No hands. 2 or 3 cases, I said. We'll talk later. Why not? Because that's what we want from states. We want states to protect our lives. We want states to take measures that are really disturbing, but that save lives. And that's an interesting approach to this proposition, because if I understood him well, Christian wants tribunals to act as some sort of parents of these teenagers called states. And that is a very dangerous proposition, because if you start second-guessing what states do in political and health and economic crisis, then we get adverse awards, and then we get regulatory chill. Then we get the decision makers having concerns about whether to take measures to protect life and to protect the economy and to protect the political stability, because there are 3 guys, usually male, usually white, usually Europeans, somewhere in Washington, D.C., deciding whether the state was right or not, whether the teenager had made the right decision. And what are the rule of law that these 3 wise men are going to apply? It's usually standards of European law or the way to do things. But they don't look at the particularities of the states. Look at the cases involving indigenous communities. How many of you have you seen indigenous communities withholding a mining project in Denmark or in Switzerland? No, you don't see that many. But when you go to our countries in Latin America and you see the importance that these indigenous communities have, you will understand why the state somehow interferes and revokes mining concessions, because the indigenous people are unhappy. That was the first point that I wanted to make. And the second one is that it's funny when we represent states and we get the statement of claim and the statement of reply, you see that normally different teams write the different sections, right? Like, you guys are going to take care of the facts and we're going to take care of the merits, and this other group is going to take care of quantum. And you see a huge difference. When you read the facts section, it usually starts with a beautiful story. We came to Latinlandia because the legal framework was stable, because there was an investment law, everything was beautiful. Why they want to portray the state that way? Legitimate expectations. We had the expectations that everything was going to stay the same. And then the second team writes merits. Everything changed when the new government arrived. Everything went from paradise to hell. It's like Dante's Inferno. We went down the 8 rings, and everything went dire. And then it's funny, because when we get to quantum, everything is beautiful again. Why? Because they're doing projections in the future. And of course, if I had kept this investment, it would have been great, because this state is growing in the economy. And they're analyzing the country risk. What country risk? This place is paradise. What Kata and I are asking you is to level the playing field, to consider that maybe not everything is paradise or hell. Maybe when you arrive to the party, things were not as you expected. And you have to take that into consideration when you analyze legitimate expectations. If you come to my house and I'm a bad cook, and everyone knows that I'm a bad cook, you should not expect to have caviar or anything. Maybe I will order Chinese and you won't like it, but you came to my house. And that's the idea that we have behind this premise. You should consider the state's political context as it was when you arrived, when assessing And it shouldn't be an appeal court. It shouldn't be three people deciding whether a Congress of 200 members were right or wrong. It should only be subjective analysis as to whether there was a proportionate, reasonable analysis between the measure and what the state did and the public policy. Thanks, Diane.
10 more minutes, rebuttal.
Thank you very much. Catalina said that it's not helpful to have a discussion in the abstract, but as the lawyers in the room here, you know very well that theory is best tested in the abstract because it removes emotion, it compels you to think in objective terms, and that's what you need to be doing here to assess the respective rights. Now, states get to decide how much protection is given in treaties, and that is what is then assessed under international law. And this idea of increased political consideration has never formed a part of international law. Why should we undo decades of the development of international law for today's proposition? It would be a radical step forward. One example that may prove this, what about corruption? We were hearing in our first debate this morning about corruption, which triggered in my mind an important parallel here. What if a corrupt state is known to be corrupt? You invest in that state. You know the rules of the game. It's corrupt. Should international law simply absorb that corruption as a standard way of behaving? Therefore, the more corrupt the state, the more corruption should be factored into the margin of appreciation in much the same way as the poorer the state, the less a tribunal should award in terms of compensation. This is what you call a race to the bottom. The purpose, Catalina said, of this system is not to protect investments. I could not disagree more. It may not be sexy to put it in these terms, but international investment law is a property right protection. It's all about property. I know it lives in the wonderful world of public international law, but it comes down to hard property rights. Investment law protects foreign investors' property rights. It has to be connected to basic standards that stretch across boundaries and supersede nationalistic idiosyncrasies. Juan Felipe talked about the COVID consequences. Well, you need to remember what international law is. It is the grown-up in the room. It is the assessment of the parent or the teacher. Regulatory chill that Felipe referenced can be overcome by treaty language. States have that power. What you can't do as a state is put your own thumb on the scale and say, I've behaved badly in the past, but you have to remember that's just the way I am. And should 3 white men decide over Congress? Well, what is international law if not supreme to national law? That's the basic architecture. Let's hope it's not only 3 white men. International law is the antidote to hegemonic power. It seeks to constrain unilateral dominance. And finally, level the playing field was the final plea for this proposition. But what they're asking you to do is not only level the playing field, but remove the state's goal so it can't lose the game.
I just want to go back very quickly to some of these principles. And I want to start back with a point to which Christian already answered. But, Christian said theory is best discussed in the abstract. And I mean, it's not only that. We're being criticized for putting things in absolute terms, but that's actually the point, right? The point is that the very fundamental nature of these protections to ensure that the rule of law is complied with means that they are absolute. That's the point, right? Now, we were told as well, currently the legal framework does allow for the tribunals to take into account these mitigating factors. And I mean, let's be quite clear about this. No, what the current system allows to is for the state of necessity, indeed to excuse wrongdoing when the state of necessity is met, right? And for certain protections to be understood in the manner that the treaty requires them to be understood. But there is no principle, as of today, that an economic crisis, that social unrest, that any of that should be considered to be a mitigating factor in determining the state responsibility. There's just no principle of international law that says so. We were told about the purpose of the system, and I think Catalina's point was, well, it is to protect investment, but actually it's to protect investment because they contribute to the development of the state. But even if we accept that as a proposition, which I'm willing to do, what you're trying, the way in which you do that is by ensuring that you're favoring investment, foreign investment into the country, right? That's how you promote the development of the state. That's what the system is doing. And you cannot do that unless you actually offer a robust response to breaches of international law. That's the point, right? Now, we were told about, well, you need to protect the ability of a state to respond in times of crisis. And I just keep on wondering, but is that protected by actually sending the message that political opportunism or economic crisis might allow you to actually expropriate or expel an investor that you simply don't like? Of course not. That does not work to attract investments, which again is the end purpose of this game, but also doesn't work in terms of what it's doing for the state and for the state ability to take measures. That's actually reinforced when the state is applying the rule of law. And we need to send the right incentives, both to the investors to attract in certain countries, but also to the states to actually apply the rule of law. And one, of course, cannot allow a state to benefit from its own wrongdoing. That's my last point. That's a basic principle of international law. And of course, that is a full response to some of the points that were being made about the country risk and how that should be calculated. And I will leave it there in the interest.
Yeah, we're almost in time, so I will have to go back and think. I will have to find 3 more white men to decide this. But only one thing, you have made fantastic arguments, and they seem very extreme, but if I move away some of the elements, it seems that we have one agreement that is the respect of the rule of law. This side made it very clearly, and this side as well. It's not that you don't apply. You apply what the treaty says. You apply what international law says. So at the end of the day, it comes to deciding in each case whether the state acted in a reasonable way. And there is a phrase that the tribunals in Suez and Total talk about that I always find very useful. It's like what a reasonable regulator or a reasonable agency would have done in that case, considering the circumstances. And that's a very difficult exercise in the abstract, but you can do it in each of the cases. And I think that's the responsibility that we're giving to the tribunals. And because we have these BITs, at the end of the day, hopefully not by 3 white men, but at the end of the day, it's for the tribunals to decide whether the state is acting within the framework of international law, having certain parameters and certain circumstances that have to be taken into account, but always respecting the rule of law. So we have 2 more minutes, and there are a lot of questions, and very interesting questions from the audience, which actually I think is great. I'll try 1 or 2 if I can, yeah. So one of the questions is, do you agree to change principles on attribution based on the degree of development of the host state? And I think that follows a little bit from the positions that you took here. And some of this has been addressed, but I don't know whether you want to add something more.
No, but it's just so in principle, right? We do have rules to determine when conduct is attributable to the state. And we have clear rules in the state in the Articles of State Responsibility. We have case law, which is actually not that clear because it's not great on the topic, if I may put it. But it is so on principle just to say that because of the level of development of a state, I'm suddenly going to change, again, the applicable principles. I mean, what does that mean? Like, what kind of predictability are we giving to investors, to to tribunals, to the state, and to the state, because allow me to make a point that perhaps didn't come out as clearly as it should, but the point that we're making is not just for the benefit of the investors, it's for the benefit of the state as well. I mean, it is in the best interest of a state to actually have clear rules and to actually be able to tell to its constituents, hey, beware. If we do this, this is going to be a breach of the treaty. And that's powerful. And that's powerful in a time of crisis, right? And so to me, no, it doesn't make any change. It doesn't make any sense to be changing well-known principles of attribution or of any other international law on the basis of some diffuse level of development. I mean, what does that even mean? Like, you know, where do we draw the line, right? So no.
That was a softball. One more question is, and maybe for this side is, do you agree with the notion of regulatory chill created by ISDS?
So that's precisely what we're warning against. It shouldn't be the consequence of the investment protection system that it produces regulatory chill. So using Carmen's words, when she says, this is good for the state, actually, it's not just for the investors, because you can tell, you know, public servants, be careful, if we do this, we're going to breach the treaty, that this cannot be regulating for public purpose. So again, we can have discussions in the abstract of what the purpose of the system is. That's perfect. But when it comes to a violation of the treaty, we need to look into the specifics of how that is being applied. So if we see a case, for example, like Eco-Oro that turned out well for different reasons, but if we take that reasoning to the extreme, which is you included an exception in the treaty that tells you that you can take measures to protect the environment, but you still need to pay, well, what that's going to cause, if it's a measure that needs to be taken because there is an imminent peril, environmental hazard, whatever, the effect of that is going to be, well, we cannot afford to take this decision because there is a mining project that is going to be valued like Tetian copper versus Pakistan, and we might have to pay $6 billion. So that produces a regulatory chill of effective or necessary regulatory action.
Can I take off the hat of this proposition? I'm tired of. My personal view is that regulatory chill is an interesting academic metaphysical theory, but I've rarely seen it in practice. I have seen states having to take decisions, and they take into consideration the risk. But I have never seen a state not making a decision because of the risk of an investment arbitration. I had the opportunity of attending a meeting with the president of the Republic of one country where they had to take a very difficult measure, and they asked us, the public international law lawyers that were there, is there a risk? Yes, there is a risk. Am I going to lose? I don't think you're going to lose, but there's a risk of losing. And then he asked a very important question, and he said, and if I lose, are they going to change the measure? And we said, no, you're going to have to pay. And he said, okay, my concern is higher than money. It had to do with public policy. So he took the measure. So I think that, with all due respect to academics, I think that regulatory chill is an interesting academic theory, but I haven't seen it in practice.
And hopefully it's not chill, but it's you put the state, hopefully, in a situation where they can think about how they want to regulate. Because there are ways to regulate without violating the treaties, and there are ways to regulate violating the treaty. And I think at some point we were given some courses to some state agencies just to understand what are the limits that they have on the basis of international law, and when just get to the same result, objective, but making sure they respect the rights that are at stake, not only the rights of the state.
We're going to do it right.
This is actually exactly the point that I was going to make, Noyana. I mean, again, taking my hat off for a moment here, but like, I don't think it's true to talk about a regulatory chill these days. Because, you know, the reality is that in most instances, what the case law is saying is, well, the issue really arises when you have promised the investor otherwise, right? Or when you're making the changes in a way that is so radical that is, you know. So, again, it's not about you're not able to regulate even in a way that is not going to attract the duty to compensate. The point is, if you do it, you have to do it right. Don't promise the investor that you're not going to do it, and do it in a manner in which you are respecting everybody's due process rights and legitimate expectations, and ultimately, again, the rule of law. So, to me, I think that the regulatory chill is a bit of a false debate these days.
Allow me to thank the panelists for a fantastic job. Good job, thank you. No, no, no.
So just a note to everyone. There is a break announced in there, but since we're off and we're trying to catch up, the break must be very, very short. So just that the next panel sets up. So if you want to go and grab something, go and come quickly. And we're going to start in 5 minutes.